All rise. Oh yay, oh yay, oh yay. This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning. Welcome to the second session of the Tennessee Supreme Court here at Columbia Central High School. This is the latest edition of our SCALES project, Supreme Court Advancing Legal Education for Students. This program brings together judges, attorneys, and students to develop a better understanding of the judicial branch of government and the role of the courts in our society. Unlike cases you see on TV, today you will hear real cases with real lawyers representing real clients and real justices deciding those cases. We appreciate your participation, and we hope that you enjoy the case you will hear today. I want to thank Principal Kevin Eady and the wonderful faculty and staff of Columbia Central High School for hosting and helping to coordinate this event. Special thanks to Judge Chris Sockwell and Presiding Judge Russell Parks of the 22nd Judicial District, as well as Murray County School Superintendent Michael Hickman, Attorney Patrick Carter, and members of the area bar associations. To the volunteer judges and attorneys, our heartfelt appreciation for your willingness to work closely with the students in preparation for today. And to the participating schools, we thank the administration, teachers, and students for your participation. We would also like to recognize the Murray County Sheriff's Office, deputies, and school resource officers who are assisting with security. Thank you as well to the attorneys who are arguing their cases today and for the extra time, travel, and preparation required for their participation. We hope all of you will stay engaged with the judicial branch after today. You can follow us on Twitter at TNCourts, on our website, tncourts.gov, and on Facebook. The opinions we write on today's cases will be posted to our website and to our Twitter feed. Now I want to introduce you to the justices of the Tennessee Supreme Court. To my immediate right is Justice Sharon Lee, a past Chief Justice of the Court. She is a graduate of the University of Tennessee with a degree in accounting and the University of Tennessee College of Law. She practiced law in her hometown of Madisonville before being appointed to the Court of Appeals in 2008. She was the first woman to serve on the eastern section of the Court of Appeals. After serving on that court for 4 years, she was appointed to the Tennessee Supreme Court in 2008. I think she was appointed to the Court of Appeals in 2004. Right. I messed that up. I didn't want to correct you. That's all right. And she lives and is from Monroe County. Next is Justice Jeff Bivens. He also is a past Chief Justice of the Court. He's a graduate of East Tennessee State University with a major in political science and a graduate of Vanderbilt University School of Law. He practiced law in Nashville and served as Assistant Commissioner and General Counsel for the Tennessee Department of Personnel. He served as a trial court judge, a judge on the Court of Criminal Appeals. He has the distinction of being appointed to a judgeship by 3 governors, Governor Don Sundquist, Governor Phil Bredesen, and Governor Bill Haslam. He has been a justice on this court after having been appointed by Governor Haslam since 2014. He lives in Williamson County. Justice Holly Kirby graduated from the University of Memphis with a degree in engineering and from the University of Memphis School of Law. She clerked for Judge Harry Welford of the United States Court of Appeals for the Sixth Circuit. She then practiced law in Memphis and was the first woman to become a partner in her law firm, Birch Porter and Johnson. She then was appointed to the Court of Appeals as the first woman judge on that court in the state. She served there for 19 years and was then appointed to the Supreme Court by Governor Bill Haslam in 2014. She lives in Shelby County. She is a graduate of Columbia Central High School. I am Chief Justice Roger Page. I'm a graduate of the University of Tennessee College of Pharmacy and the University of Memphis College of Law. I clerked for Judge Julia Smith Gibbons when she was on the U.S. District Court in Memphis. She is now on the Sixth Circuit. I practiced law for 14 years as an assistant attorney general and then in private practice. I was elected circuit judge in 1998 and appointed to the Court of Appeals by Governor Haslam in 2011 and to the Supreme Court by Governor Haslam in 2016. I live in Chester County. As you can see, we're from different parts of Tennessee and went to different law schools in Tennessee. We are all native Tennesseans. We all consider it a great privilege to serve on the highest court of this state. We are committed to upholding the Constitution, protecting the individual rights, and applying the laws of this state. Also, our Supreme Court consists of 5 members. One of our members, Justice Connie Clark, passed away on September 24th of 2021. This is the first time we've had court in person without her, and we miss her very much. She was one of the best people I ever met, and also an extraordinary judge and justice. But she would want us to go forward, so it's almost time to go to work. I will tell the attorneys who are arguing, you have 30 minutes per side, and if you wish to reserve any time for rebuttal, when the appellant comes up, just let us know that. At this time, Mr. Jim Hibner, our appellate clerk, will call our second case for the day.
Mindy Donovan versus Joshua R. Hastings.
Your Honors, good morning. Ben Rose on behalf of the appellant, Mindy Donovan, and we've requested 4 minutes for rebuttal time. I do want, because of the special circumstances that we find ourselves in with the Scales Project, I do want to thank the court for allowing us to do this oral argument in this setting, particularly as it relates to the high school students that are here. I have a long history of supporting efforts such as the mock trial program, particularly in Williamson County. I don't know if there's Williamson County students here or not, but I certainly like to see them participate and be interested in the subject matter. I think it was former retired Judge Harris that remarked as part of our mock trial proceedings that he always liked to see young people involved positively in our justice system as opposed to the other way around. So I appreciate having the opportunity to participate in this oral argument in that context. And let me just say that, first of all, this is really a simple case involving some relatively simple statutory language, but it has enormous consequences because we are very concerned as part of our argument and as we've briefed that if the majority opinion of the Court of Appeals is ultimately upheld, the effectiveness of a statute, an important statute, the loser pay statute, will be no longer and will not be effective. And just for the edification of our audience, perhaps I should say a little bit about the loser pay statute. I know your honors certainly are very familiar with it. There's been a few cases in front of the Supreme Court specifically related to it. But for the edification of our audience, a few years ago, the legislature, in I guess their collective wisdom, decided to pass a statute that afforded a litigant that was successful in dismissing a case to obtain their attorney's fees in the form of costs up to $10,000. As we all know, generally speaking, as lawyers, we follow the American rule in the state of Tennessee with regard to your attorney's fees. Typically, you cannot recover your attorney's fees unless there's a statutory provision or contractual provision that would allow you to do so. Effectively, when the General Assembly passed what's called the loser pay statute, it started to change some of that rubric and allowed litigants that are successful on a motion to dismiss, specifically a 12.026 motion, to effectively obtain some relief from the other side through payment of their costs in the form of attorney's fees. And that's the legal piece of it. And ultimately, as we've briefed, your honors, there are sub-issues, and we certainly don't want to waive those. We want to talk about those. But the main issue is where you have a claim that's been filed, and essentially that claim remains, even though there's a technical amendment under Rule 15, and that claim is eventually dismissed. What do the following provisions of the loser pay statutes mean? Not in terms of also, what do they mean collectively, and what do they mean as applied? The provision in C1 related to fees incurred in the proceedings as a consequence of the dismissed claims by that party or parties, and the language in subsection C2, all reasonable and necessary litigation costs actually incurred due to the proceedings that resulted from the filing of the dismissed claims. The majority opinion, I think, at least according to Judge McBrayer, who wrote the dissent, got the rule right, but he differed with the majority in as much as it was applied. Essentially, the court said this was to be broadly interpreted, but in this specific instance, narrowly applied in limiting or upholding the limit of recovery of attorney's fees to my client, Ms. Donovan.
Mr. Rose, what are the words here that we're actually trying to suss out what they mean? Is it simply in 2012-119C1 down toward the bottom where it says, incurred in the proceedings as a consequence of the dismissed claims by that party or parties? Is that what this case is all about, what that means?
Well, with regard to the majority opinion, they focused on proceedings and what proceedings mean. I think Your Honors have to, we're bound by the statutory rules, constructing rules and interpretation rules, to read all that together. But you also have to read it within the rubric of the statute. I think we just recently had a Court of Appeals opinion that came out right around Thanksgiving that says that the loser pay statute is a remedial statute.
Well, you're saying proceedings encompasses everything, not just what's in the amended complaint.
Absolutely, and particularly here, and I think that was Judge McBrayer's issue, was here there's no real change in the substance of the claim. So from the beginning of the claim, it's a breach of contract claim related to alleged unpaid services, and that essentially, that claim continues even though it's technically amended and is ultimately what is dismissed. So our position would be, and it's, by the way, it's not the position we took in the underlying proceedings, but our position would be that you could claim under the correct interpretation of proceedings fees from the very minute that counterclaim, that original counterclaim is filed up until ultimately the amended counterclaim is dismissed. Now, in this case, we didn't go that far, Chief Justice. We actually asked for fees starting with the proposed amendment, which we all knew was going to be agreed to and ultimately became part of the record, and then started from that point on.
Would that have something to do with the limitation on the amount you could get?
Perhaps.
Okay.
But, you know, as a litigant, we're always asking for more, Judge. So, and it's one of the points we made as part of our briefing, that, you know, this statute should be interpreted broadly for purposes of its aim. And its aim is to, if we have a claim that is dismissed in whatever form, everything that touches that claim, there's a debate in the briefing about related to. Well, that's not the language of the statute. It's a consequence, is the language of the statute related to the proceedings. That's
So was the breach of contract claim that was dismissed in this case, was it set out in the original complaint that was filed?
It was, Your Honor.
Okay, so, all right, are we talking about the counter complaint or the original complaint? We're talking about the counter complaint.
We
right?
are, and I may have misspoke. I'm sorry.
Okay, all right, so in the original, the plaintiff files a complaint against this contractor.
Yes.
The contractor then files an answer which says, I didn't do anything wrong, and then files a counter complaint against the homeowner.
That's correct.
The counter complaint contained the breach of contract claim that was dismissed, right?
That's correct, Your Honor.
And then that counter complaint was later amended.
That's correct.
Are you asking for fees from the original counter complaint filed by the contractor?
We are not, Your Honor. I was just making, Justice, I was just making the point that I believe the proceedings language is broad enough to encompass that. But as it relates to this specific case, our claim begins with the motion to amend the counterclaim and the proposed amended counterclaim. Essentially, and I had that in the facts, Justice. Essentially,
and it confused me, frankly. I thought, why would it not include fees back to filing of the original counter complaint? And are you asking us to interpret it? I mean, we have to interpret a statute for all the cases that may come in the future. Is there a quirk in this case where you did not ask for fees going back to the filing of the original counter complaint?
it was strategic, Justice. That,
Okay.
I mean, the fees would have been well over $10,000.
Okay.
And for example, we referenced in the briefing, you know, we had a day and a half deposition, and a lot of that deposition had to do with the counterclaim, and we could have included all that time. We didn't include that time. But just so we're clear, our position is, I believe the statute and the intentions of the statute should be construed as broadly as possible and would begin with the original filing of the counterclaim.
All right, well, let me ask you another hypothetical then. suss this out a little bit, because we do have to issue a ruling that takes into account all the different ways this could play out in a future case. Let's imagine that the countercomplaint here did not contain the contractor's breach of contract claim against your client.
Yes.
He then files a motion. Trial judge, I want to amend my countercomplaint to include a breach of contract claim. Will you, trial judge, allow me to amend my countercomplaint to include this new breach of contract claim? Do you say that the statute, and let's say the trial judge ultimately says, yeah, sure, you can. Do you say that the statute should be interpreted to go back to the motion where he asks the trial court, can I file a new counterclaim, a breach of contract claim?
My answer to that would be yes, Your Honor, if the time claimed relates to the amendment that was ultimately allowed. So, for example, in our case, just to we step back for a moment factually,
Okay.
What happens is we file a complaint or a lawsuit related to construction defects for remodeling contracts. As often happens, a counterclaim was filed alleging failure to pay for those services. There was then an amendment later on in the litigation. There was a proposed technical amendment that revived that counterclaim, but the substance of it was still the same. It still was a breach of contract. When we saw that claim, that proposed amended complaint, immediately, because we knew that given the liberal interpretation of Rule 15, that we would get that amendment that would be granted, and I think we actually acceded to it. It's typically what we would do. We immediately began to analyze, for purposes of a motion to dismiss, that proposed amended complaint. And we didn't claim fees for anything until that process started, which was ultimately excluded.
All right,
by
well,
the
let me
trial.
tie that back to the language of the statute, to Justice Page's question. What we're doing here is interpreting the loser pays statute. And the statutory language refers to the consequences of the filing of the claim. So in my hypothetical to you, there's a motion asking the trial judge for permission to file this claim. So how do we then interpret that language to include the fees incurred where you're opposing the motion to amend, you're researching it, all this kind of stuff, before the trial judge says, yes, Mr. Contractor, you can amend your counter complaint to include this breach of contract claim?
Our response to that, Justice, is it doesn't really matter temporally as long as it relates to the actual filing that's made. So if it was 6 months before and it was time that was spent on something that was filed and then subsequently dismissed under the loser pay statute, it doesn't matter in our view, under the interpretation of proceedings.
So how do you define the term in the proceedings that's used in the statute? What do you think in the proceedings means?
Well, our view is that in the proceedings is any type of proceeding that's related to what is ultimately dismissed. And that's why you go beyond just the technical amendment and go to the substance of the original claim.
So it would be the filing of that counter complaint. That would be the proceeding. So it's a proceeding within a proceeding, essentially. It's not like the whole big case from the day the complaint is filed is the date from that counter complaint is filed that it is ultimately dismissed, right?
If I'm following your question, I believe so. I want to be careful because it could be. I mean, again, broadly interpreting what proceeding is, you could have scenarios where everything or almost everything that was done in the litigation relates, for lack of a better descriptive term, to what was ultimately dismissed. And I really think that
It is a broad term. The legislature could have used, from the date the dismissed claim is filed. I mean, the legislature could have really narrowed that, but they used a broad term, and I think that's what makes it so confusing. Because often there are many claims within a single lawsuit.
Counsel, I want to go back to your comment about this is a remedial statute and should be interpreted broadly for that reason. As you indicated in the beginning of your argument, historically, our legal system is not a loser pay situation, correct? So the common law situation unless there is a statute that allows them to do that. So in that instance, shouldn't we strictly construe the statute? Because it's in derogation of common law as opposed to a remedial statute.
Justice Bivens, I think that's the correct analysis, except for the fact that you do have a statute that has specific purposes behind it.
Well, and I don't disagree, I understand the language of what the language means is a different question. But to rely on statutory interpretation provisions saying it's a remedial statute, I think may be going too far.
That's certainly a possibility, Your Honor. Again, we would rely on, because you have a derogation of the common law rule, in this specific instance, essentially, for lack of a more elegant way to describe it, Justice, the legislature has said, if you dismiss claims, we want everything that's related to or encumbered by that claim to be included as part of this penalty.
Well, but isn't the better way to phrase that is the plain language of the statute allows the remedy that you're seeking?
I did say it was inelegant, yes, Your Honor. And certainly the legislature could have been clearer and they could have defined proceedings and perhaps we all wouldn't be here, but they didn't do that and we're stuck with what we've got and we've got to deal with it. And again, I think the emphasis needs to be on what are the aims of the scheme itself. And if we, if you take the majority's approach and say, well, we're going to look at Rule 15 and even a technical amendment is where you have to begin your analysis, then you've got a lot of problems in terms of trying to make the statute effective. It renders it neuters the statute.
Is there any legislative history that's helpful?
There is legislative history, and that's been recently in the Court of Appeals opinion just came out on other issues that's been analyzed by the Court of Appeals. Here, the Court of Appeals did not apparently feel like the term was ambiguous enough to need to go to that and interpreted proceedings according to the Black's Law Dictionary. So, but there is legislative history that relates.
Do you think we should consider it? Do you think this term is ambiguous such that we should consider it?
I don't, Justice. I don't believe it's that ambiguous. I do believe, just like the majority opinion and Judge McBrayer, we can look at these particular provisions together with the broader scheme of the looser pay statute and affect the legislature's intent. If I may just briefly, we got off on the law. I'm sorry we got off on that and didn't get into the facts because I did want these folks behind us to know a little bit about and be able to relate to the facts. This was a generic contractor dispute. This is all pre-COVID related to my client's home. She had 2 renovation contracts that she entered into with Mr. Hastings, the contractor, the appellee here. These contracts were very unique in that they were extremely simple and extremely non-consumer friendly, for lack of a better term. For example, they contained a attorney fee recovery provision or indemnity provision that purported to allow Mr. Hastings to collect his attorney's fees even if Ms. Donovan won her case. So it essentially was a double recovery of the attorney's fees provision. It also had a unilateral termination provision contained within it such that Mr. Hastings could terminate the contract at any time, but Ms. Donovan could not terminate the contracts for any reason.
She had not hired you at the time that she signed this contract, I assume.
That is correct, Justice. Sadly so. One of the first things, obviously, we did was we attacked that indemnity fee provision or attorney fee recovery provision, and we obtained summary judgment. That provision was stricken from the contracts, and we went forward with the litigation. And really what we did in terms of investigation, and it's in the record, we found that Ms. Donovan's situation was not unique, that in fact there were many other folks in the area that had the same types of complaints about the work that Mr. Hastings performed. And we incorporated some of those complaints, including complaints even to the Better Business Bureau or other third parties, together with our counterclaim, or with our claim, our original claim. And sadly, unfortunately, Ms. Donovan developed priorities other than litigating her residential remodeling contract case and had to move on. As a result of that, that's when we had to file our motion to dismiss related to the amended, by that point in time, counterclaim, and then we also had a motion to allow us to non-suit a couple of claims that were subject to a pending summary judgment. Those motions were granted, as the court knows. We subsequently, after the case became final, we subsequently filed our loser pay motion. That motion was also granted, but unfortunately the trial court limited our request for recovery from $10,000, some 2/3 to a mere $3,600. And the court, in rationalizing the reduction, essentially had 4 justifications for why it did so. It excluded fees before the technical amendment was actually filed, as we've talked about before in terms of the actual amended counterclaim. It excluded fees not related to, at least in the terminology of the trial court, the motion to dismiss. The other one that I thought was interesting that we may talk about in a moment in terms of the public policy was the court, and I think this really was the driver behind the trial court's decision. The court looked at the Rule of Professional Conduct 1.5A4 and looked at the amount involved in the results obtained. And essentially the court is saying for the claim that was at substance of the amended complaint, it did not justify the amount of work that was conducted to have it dismissed. And then finally, the trial court actually did not allow us to recover any fees for the actual motion to dismiss itself, which was puzzling given that you would think at least that part of the claim would be sound, even with the analysis that the majority of the Court of Appeals adopted. We filed an appeal. This case went before the Court of Appeals in the middle section. And of course, we had the majority approach came out that essentially broadly interpreted the provisions we've talked about, but according to at least Judge McBrayer, narrowly applied them, or too narrowly applied those. Judge McBrayer wrote a dissenting opinion, which obviously we agree with. It's helpful to our position. But I want the court to know that our position is not limited to the statutory interpretation issues that are at the base of Judge McBrayer's opinion. We feel like there were some calls that the trial court made that would normally be governed by the regular standard of review, but that in fact they rubbed up so much against the loser pay statute that in fact they violated the statute and should be reversed on that basis as
Counsel, let me ask you this question. If we agree with you that the time the clock starts ticking or the time starts adding up from the date that counter complaint is filed, do you max out on the $10,000 amount without those charges that the trial court excluded based on not being reasonable and necessary? Does that make sense? In other words,
I think so, and I think my answer to that is no, probably not, because we
Okay.
pegged it with the proposed amendment and the analysis that followed from that. And so I don't think so. I think there's a substantial amount of time related to the analysis of the proposed amendment that was actually incurred before the actual filing of the amending.
You're
I mean-
asking us to go back to when the motion to amend the counter complaint was filed.
At least. That was
Right.
where we pegged our
And if we-
request.
if we do that, I didn't state that right. If we go back to the date the motion was filed, as you argue, do you max out even without those claims that the trial court kicked out as not being reasonable and necessary, like double billing and sending 2 lawyers to do the job of 1, et cetera? Is that additional time being tacked on sufficient to put you over the limit? Or do we need to review those charges the trial court disallowed as reasonable and necessary?
Justice Lee, if I'm understanding what you're saying, I believe we would not max out, because remember, our request was for $10,000 total for the
Right.
period of time, and then whatever was done with that with the trial court and the Court of Appeals was done. So we don't have, now, that's not to say that if the case is remanded to the trial court, we couldn't submit additional time within the ambit of this court's opinion if this court was going to pick up that.
But you're
that
saying
timeframe.
that your actual fee affidavit that you submitted to the trial court when you filed your request for an award under the statute was right, it was exactly $10,000?
It was, Your Honor.
Yeah.
It was.
And-
But even if the statute is interpreted to go back to the motion to file the amended counter complaint, or even back to the original complaint, which contained the breach of contract claim, it's still subject to reasonableness, is it not?
Of course.
Always subject to that.
It absolutely is. And
So the trial court could have it go back all the way to the original complaint and still say the amount of fees that you generated in response to this was excessive.
Absolutely, absolutely. And of course, with the caveat for the factor that we talked about in terms of the results obtained.
Gotcha.
I only have a couple of minutes left for my main argument, and I do want to get to what my old professor of torts at UT, Joe King, called Mr. Mustard, which is the public policy component of all this. And I'm not being hyperbolic, I don't think, when I said at the beginning that really, if the majority opinion, and I'm not sure that this was the intent, but looking back on it now, if the majority opinion is left to stand, the loser pay statute is not going to work anymore. And it's not going to work anymore because crafty plaintiffs' lawyers are going to do this. They're going to file their lawsuit. They're going to wait and see, is an aggressive defense lawyer going to file a motion to dismiss? When that happens, they're going to assess the merits of that motion to dismiss. If it doesn't have much merit, they're going to go forward and they're probably going to win. They'll be fine. If it has some merit or they're concerned about it, what can they do now under the majority opinion? They can technically amend as a matter of right under Rule 15, maybe change the addendum, maybe increase the addendum by a few dollars, and suddenly they have an entirely new lawsuit, which obviously the same defense counsel or defendant is going to file another motion to dismiss, the same type of motion to dismiss. And if that motion to dismiss is granted, that plaintiff's attorney, it faces what? What's the penalty under the loser pay statute? Maybe the cost of the hearing? I mean, that is effectively what will happen, and what I know is happening, because I'm hearing from those folks, as a result of the majority opinion. That's what people will be able to do. The other aspect of this, in terms of public policy, and I know my time is running low, that I want to hit on again, is if you have a results obtained component within the reasonableness of these fees, think about what that means. I mean, I understand in the garden variety world, like Killingsworth, for example, you've got to be able to assess, well, are you working efficiently enough to get this result? I understand that. But what are we talking about? We're talking about at least what the legislature has deemed to be frivolous claims. Those are claims that aren't worth very much, but they're hard to get rid of. And by their very nature, they're going to fail that test every time because they're not very valuable, but they're stubborn to get rid of, and that's why the legislature specifically included a procedure to do so with the penalty. I see my time has expired. Thank you.
Good morning. If it please the court, Jeffrey Spark, I represent Josh Hastings in this matter. I want to thank the court for allowing me the opportunity to relive my worst high school nightmare by presenting in front of the entire class.
Wait till we have to answer their questions.
Yeah. I think the court has honed in on the main issue here, and that is the meaning of the word proceeding as it applies in this case. The other issue as it relates to whether the fees actually awarded were reasonable and necessary, that's the second issue. Does proceeding in this case relate back to the original pleading that was filed, the countercomplaint filed by Mr. Hastings? The Court of Appeals majority opinion found that it did not. They found that because the statute specifically references when the claim was filed, that it relates to the amended countercomplaint. But Judge McBrayer found that that was too narrow a view. It should relate back to the original pleading that was filed in as much as the statute references proceeding. Now, I'm in a rather odd position here because in some ways, Mr. Hastings wants to embrace that dissent. But as we argued in the Court of Appeals and before this court, if you do that, the other important term to mention is claim. Nobody has, your honors have asked questions specifically referencing claim. Ms. Donovan doesn't want to talk about that term too much, because if she does so, she has to acknowledge again that that claim, as Your Honors pointed out correctly, was filed in the original countercomplaint. If that's true, and we follow Judge McBrayer's logic, then theoretically, Ms. Donovan would be limited to the 60-day deadline to file a motion to dismiss in the statute.
But that was not raised as an issue to us on
It was.
appeal, was it?
It was.
Was it?
It was raised both on appeal and before this court.
Okay.
Our position has been all along that if we rely on the word claim, then they were required to file this motion to dismiss as soon as they were on notice that the claim was subject to a motion to dismiss. And bear in mind, the claim with respect to attorney's fees was filed as a motion for summary judgment, but there are subsequent pleadings where Ms. Donovan acknowledges this is just a question of law. It could have been filed as a motion to dismiss, but was not. So they had an opportunity to address the attorney's fees claim and this claim, the breach of contract claim filed by Mr. Hastings, at the same time, but didn't do so. So the remedy here for Ms. Donovan was, if they wanted all their fees related back to the initiation of the proceeding, then you file that motion to dismiss at the initiation of that claim, the original countercomplaint. That was not done. Almost a year passed. When Mr. Hastings amended his pleadings, the claim didn't change at all. The only thing that changed was, as acknowledged, was a technical reference or a technicality as it related to the addendum, the damages.
But doesn't that argue against your position in that if we agree with you that the time starts running when that particular claim is filed, the amended countercomplaint, what would stop a party from just filing a technical amendment just to get the clock to restart and then cut out a lot of attorney fees?
And that was I appreciate that question. That was the public policy, the main public policy issue raised by Mr. Rose. And I would argue, and I argued at the Court of Appeals and before this court, that the problem with that is that it's not an amendment as of right. You have to file a motion to amend. Okay. And if a motion to amend simply, I think the case I cited in my brief says, regurgitates the same cause of action, it can be denied. An amendment.
No, but those motions are freely granted. I mean, we have that in the rules. So if you file a motion to amend, you pretty well can count on it being granted, right?
I don't think you can. If a motion to amend is filed and simply recites the same cause of action that was in the original, there are plenty of cases, and I cite them in my brief, that say we're not going to let you amend it to include that. You've already included that cause of action.
You would make a little change, like maybe instead of suing for $100,000, you raise it to $500,000, and that's it's a different case then.
That's true, but that's my entire argument. That's just the damages. That's not the original claim, and that's the problem here. If you include the same claim, you're not changing your pleading to that extent. That is just a regurgitation of your same cause of action. And that, I think, any trial judge would say, I'm not going to let you do that. You can change the addendum, you can change your theory of damages, but if you include the same claim, I'm not going to let you amend it, particularly if there is a motion to dismiss pending. Any opposing counsel to that motion to amend would point that out to the court. Judge, I've got my motion to dismiss pending on this claim. He's recited the same claim. Obviously, under the loser pays statute, this plaintiff, or counterplaintiff in this case, wants to get around that.
But that's not what happened here. I mean.
No, it's not what happened
No allegation
here.
made here, that's what happened. But the amended countercomplaint really, I thought it only changed the relief sought, right? So
Exactly.
So essentially, the breach of contract claim was the same in the original countercomplaint and the amended.
It was exactly the same. And
So what you're saying is you can't refile the exact same claim, is what happened here?
no. What I'm saying is that if you're going to file the exact same claim, then your remedy is to file your motion to dismiss when the original claim is filed. And that's why the public policy here is not, as claimed in Ms. Donovan's brief, just deterrence. As I claim in my brief, it's the ability for a trial court to narrow issues. That's one of the main roles of a lot of our motions. You've got any number in under Rule 12 that allow claims to be narrowed down. You've got Rule 56, summary judgment, that allows for narrowing of claims also.
Counsel, let me go back to your original statement, that you brought up the fact that it's sort of a gotcha argument. If the time period for attorney's fees go back to when the original breach of contract claim was filed in the countercomplaint, then your opponent is precluded from recovering attorney's fees because the statute requires that the motion be filed within 60 days.
Yes.
And I asked you about raising that as an issue. And you said, oh, we raised it as an issue.
Yes.
I want to understand where you're saying in your brief. I'm looking at your brief, and it says statement of the issues.
Mm-hmm.
It says issues of appellant. Whether the majority opinion of the Court of Appeals erred in upholding the trial court's limitation of the appellant's recovery of costs and attorney's fees in the amount of $3,600 under the statute.
Okay.
I do recall some discussion in your brief in the course of, as part of the history of these proceedings, but where are you saying that you raised that as an issue?
Well, I'm not sure you're looking at the right brief because you said appellant, and I'm appellee. So I want to be certain.
It says issues of appellant. I don't,
Oh,
I'm not saying.
I thought you said appellant's brief.
Well, I'm looking at your brief.
Okay, that's fine.
I'm looking at your brief, statement of the, there's a section in the brief
Yeah.
on statement of the issues. That's where every party is supposed to lay out the issues
Right.
that they are asking us to consider. So where is that in your statement of the issues, or are you asking us to consider it in some other part of your brief?
Well, first of all, let me point out, I believe I also raised this in the trial court. I don't think I just raised it on appeal the first time.
Okay.
I
Okay.
stated specifically in the trial court that if you don't raise that claim issue within 60 days, you're barred from recovery. I argued that in the Court of
Right.
Appeals. In fact, the Court of Appeals specifically
They addressed
referenced
it.
that. They actually addressed that.
Addressed it. You understand that when an appeal comes to the Supreme Court, there are defined issues that the parties are asking us to address.
Right.
And so I want to understand where you raised
It might
that
take
issue.
me,
Yeah.
I don't think it'll take me 18 minutes and 20 seconds to find it, but give me just a few seconds.
And if you want to supplement after the fact, I understand that your time here is
Right.
limited. If you want to address that in a follow-up letter to the court, that's fine.
Okay,
But people don't appeal, and we just look at everything that might come up. And it's also a situation where you are asked in your brief to define the issues so that your opponent is not surprised by an argument. Everybody comes up here knowing what both sides are going to argue, and we know what they're going to argue so that we can formulate our questions appropriately.
Right.
So if you want to, I don't want to knock you totally off course, you're welcome to follow up with a letter.
Page 55 of my brief. The dismissed claim was the claim that was filed with the amended countercomplaint. To hold otherwise is to concede Hastings' argument in the trial court that Donovan's motion for costs and attorney's fees was ill-timed and barred by 2012-119C5B, which required that the motion to dismiss must be filed within 60 days after the moving party was served when the claim was first made.
Well, I'm not saying that that wasn't alluded to in your brief, but you understand that there's a separate section of the brief where the issues are laid out separately, and I'm just not seeing that.
Well, I just addressed Ms.
Okay.
Donovan's issues.
Okay,
I
gotcha.
wasn't making my own issues. I was just
Okay,
responding
got
to
you,
the
got you.
those
That
issues.
helps us understand what's before
Right.
us. I appreciate that.
Right. Okay, so, again, back to this proceedings issue. I've touched on Judge McBrier's dissent and how we could agree with that. If you included the word claim, it would be time barred. Now, if we look at the majority's opinion that focused on the word proceeding, they focused on they looked at the entire statute in context. In particular, the language, and I think Your Honor pointed this out, that it relates back when the claim was filed. And the Court of Appeals rightfully pointed out that when you file an amended complaint, it supersedes the original complaint. So they were looking solely at when the new counter-complaint was filed, about a year after the original counter-complaint was filed, and that's where they said the clock was reset. So Ms. Donovan had an opportunity to come back and file that motion to dismiss, but she couldn't go back to the beginning. Counsel argued that he would not go back to the beginning. Counsel argued that he would only go back to when the motion to amend was filed. Although he could go back further, he alluded to depositions and part of the record with that respect. With all due respect to counsel, that would include everything. A proceeding would include everything back to the original counter-complaint in this case. So theoretically, and he actually said he could file a motion to include additional time.
Well, how is that not the correct way to interpret this statute, though? The breach of contract claim was filed as part of the original counter-complaint. And of
Yes.
course, we have to look at all the different kind of fact situations that may come up. How is that not the correct interpretation of this statute?
That proceeding goes back to the original counter-complaint?
Yeah.
The majority opinion looked at the statutory language that says when that claim was filed. So that's your first response. The second argument is that it's very broad to go back to proceeding and try and suss out items that were not related to.
Trial courts do that all the time. They suss out, and they have to look obviously at the reasonableness of the fees. The burden is on your opponent to
Right.
show that, this much time was spent researching this issue and this much time was spent researching. And if they can't, that goes to more the burden of proof. But the statute, the language of the statute allows an award of necessary attorney's fees incurred in the proceedings as a consequence of the dismissed claims. That's broad language.
When it was filed.
Does not say that.
It does say it
The
later.
second part of it says, refers to attorney's fees incurred due to the proceedings that resulted from the filing of the dismissed claims.
Right.
So in this case, why would that not relate back to the filing of the original countercomplaint? Even if they didn't ask for attorney's fees going back that far, why would we not interpret the statute to provide for that?
Well, I would kind of throw that question back at the court and ask if you're going to
No,
do that.
you don't get to do that.
If you're
You have
going
to answer the question, then you can follow up, but you have to answer the question
If you're
first.
going to do that, don't you then have to include the word claim? And if you do that, if you look at the claim, again, it's when the claim was filed. You've got a clock ticking as
So
soon as
when
that...
was the breach of contract claim first filed?
The breach of contract claim was...
Your breach of contract?
Right. Was first filed on 7/18/18.
Is that the date of the filing of the original countercomplaint?
Yes.
That's my question.
Right. So
Okay.
there's a clock starts when you do that. You've got to file your motion to dismiss within 60 days.
And that didn't happen.
That didn't happen.
That didn't happen, but you don't raise that as a separate issue in this appeal.
These are not my issues to raise. This is appellant's
Actually, on
issue.
appeal,
And
the appellee, once permission to appeal is granted, the appellee can then raise his or her own issues.
I argued that issue in my brief as part of my argument against counsel's, Ms. Donovan's position.
Right.
But your adversary didn't request fees back until the date, as of the date the original was filed, so that's not really before us. What they asked for was fees from the date the motion to amend the countercomplaint was filed, which puts them within the 60 days, correct?
I'm sorry, repeat the first part of that.
They asked to receive fees as of the date the motion to amend the countercomplaint was
Correct.
filed, which was, then they filed their motion to dismiss within 60 days of that date.
Correct, after the
So
amended
the
files.
timeliness really is not an issue. Timeliness of the motion to dismiss would have been an issue had they tried to go back to the date the original countercomplaint was filed on 7/18/18. But because of the way they filed it, the timeliness.
Right, but the
It
problem
isn't
is, that Judge McBrayer's dissent, the practical effect of that is that it allows the court to go back all the way to the beginning of the commencement of whatever claim we're talking about, original or otherwise. So that's the problem that I think your honors have to wrestle with. Do you go back to the very beginning, and then as counsel suggested, I'll allow him to, although it's not in his brief and never really argued, allow him to amend from that point forward his timesheet so he can get more time.
Isn't he only asking for time that it was disallowed between February 1 of 19 and March 29 of 19?
Yes.
Okay.
When the motion to amend was filed. Yes, that's correct.
Well, counsel, what would be wrong, for example, if, in our opinion, if we interpret the statute to say that fees are permitted to go back to the first filing of the claim that was dismissed, which here would be the filing of the original countercomplaint. But in this case, Ms. Donovan only sought fees going back to the motion to amend. What would be, so that's the maximum that she would be allowed. Again, on appeal, she's precluded
Yeah.
from going back to the filing of the original countercomplaint because she didn't ask for it to begin with. And she can't go back and ask for it now.
I don't think she can either, but the problem is that if you embrace that, then you kind of open the door to allow future litigants to do exactly that. I don't think, but again, back to that public policy argument, I don't think that an existing countercomplaint like we have here that's been, that a party requests to amend is going to be just allowed to do that if that same countercomplaint already exists. That's sort of the point. You're not just going to get a blank check from a trial judge to amend your pleadings when a motion to dismiss is pending.
But how
Same
does that
claim.
argue in favor of an interpretation saying that fees are only allowed back to the time that the amended claim was filed, which is basically the position that you have taken in your brief, right?
Right, but that's what the statute
So
says.
how does that,
That's exactly what the statute says. It says when the claim was
Right.
filed.
gotcha.
And you have to read both of those provisions in context and as a whole. You can't cherry pick the language. That's the problem here. Council wants you to just look at the word proceedings and focus on that, when it's not that simple.
Okay.
Now, the other issue that council raises is whether the fees were reasonable under the circumstances, and of course, that's a discretionary issue left to the trial judge. And counsel in his brief mentions that several instances where he believes the trial judge abused her discretion. First of all, he claims that she didn't review the records and the timesheets and the expenses, but she clearly did. She said she did, and the Court of Appeals acknowledged that she did. And I don't think that you can find in the record any indication that she didn't. The language that the trial judge used in addressing the claims she was not going to allow is reasonable and well within the discretionary standard of review for a trial judge. It is the movant's burden to prove their attorney's fees. I don't think that Ms. Donovan did a particularly good job in doing so, and one example is the request for fees for that motion to dismiss hearing when there were two motions heard. The time for that was not delineated. And that's a pretty common thread in our appellate court cases. You have to delineate what time was spent. It's not up to the judge to figure it out. Some of the other issues are whether or not this was such a simple issue that there should be limitations on what is awarded, and our position is if you just look at what was filed, both the motions and the order, they weren't long. The issue was pretty straightforward. It was pretty simple, and she found that. So for the last few minutes of my argument, I want to address the public policy question because it's a little troubling here. I think counsel, with all due respect, contrary to what he said, is being a little hyperbolic. If your honors, if this court rules to uphold the Court of Appeals decision, it's not going to be an earthquake that totally destroys this statute. It's not going to eliminate the ability of a party to file a motion for attorney's fees and be awarded those fees. There is nothing in this case which is so earth-shattering that it's asking this court basically to denude this statute of any force and effect. Our position is that the clear purpose of the statute is not just to deter claims that have no merit, it's also to limit the movant's, let's say, leeway in asking for fees and spending time on a motion that is, by definition, limited. That's the, I think, the main reason this statute exists. It wants to, as I said before, trial courts want to limit issues. That's what this does. Just because this court says that it is limited to when the claim is filed does nothing to limit a move-in's ability to request fees and costs. If there are any other questions, I have a few minutes, but I don't think I have anything further to add.
There's no penalty for not taking all your time.
Yes,
Thank
sir.
you.
Yes.
Just a few brief points, Your Honors. To reiterate Justice Kirby's points raised in questioning, the issue of going back and somehow violating the 60-day statute provision within the loser pay, that was not raised. It was not raised according to the standards that are required for briefing on appeal before this court. And I would point out, we did not file a reply brief, and if that issue had been raised, we obviously would have filed a reply to address those concerns. Having said that, Your Honors, I think it's an apples to oranges argument. Mr. Hastings is essentially using, on the one hand, the rules of civil procedure, which is very clear, the lineage of cases that say once you amend, even if it's for a technical amendment, that is a new proceeding, if you will, or claim. And he's using that against the statute that's at issue with the loser pay and trying to meld the two concepts. They cannot be. It's clear that once you amend your, in this case, a counterclaim, we're entitled to another 60 days, which again, as Justice Kirby pointed out, is what's relevant here. I want to be clear on this, that with regard to this particular claim, we've only asked for those fees incurred beginning with the motion to amend containing the proposed amended counterclaim. But I do believe that for purposes of other cases and as part of what this court is designed to do, that in fact that language should be interpreted as broadly as possible. And I believe it does ultimately go back to the beginning of the counterclaim, the original counterclaim, so long as you're consistent with the same type of claim, even through a technical.
Well, isn't what you're, assuming the issue's not been waived, isn't what opposing counsel is arguing, it's an alternative argument, is it not? In other words, if we accept the majority's approach to the statute, COA majority's approach, then you're cut off from going back past the amended counterclaim. However, if we accept Judge McBrayer's position in his dissent, then you theoretically could recover those charges, but then that kicks in the 60-day provision. So they're really alternative arguments, aren't they?
Right.
Well, the problem I have with that is if that was provided for in the statute itself, then I wouldn't have a problem with that analysis. It's not in the statute. It doesn't say, well, once you start an original claim and then we go down the continuum and there's an amended claim. It doesn't treat those claims as separate and set aside different time periods or exceptions for those. So the problem I have is you've got rules against the statute here, and in our view, that does not result in something that's favorable for Mr. Hastings. The other point I would make just briefly about in terms of what the trial court did in terms of determining reasonableness, again, we understand that it's a trial court's job to determine the reasonable and necessity aspect of claim fees. I get that. But here, not unlike Killingsworth, which I was a counsel for in the original Killingsworth appeal, the same thing the trial court did there. He rubbed up against the statute or the remedial scheme and violated that scheme in purporting to reduce the fees. And we believe that would be the same thing that the trial court has done in this particular case. It is not hyperbolic. The future of, I believe, the loser pay statute lies in your hands. If the majority opinion is sustained, I believe that the effectiveness of the General Assembly statute will be thwarted.
Well, the legislature can always amend the statute, too.
It certainly can. It certainly can. I would hope that wouldn't be necessary, Your Honors. In any event, I appreciate your time and your questioning. We would ask that you reverse the majority opinion consistent with Judge McBrayer's dissent and the other arguments contained within our briefing. Thank you.
Thank you, counsel, for your arguments today. We appreciate you taking your time and extra travel and to participate and prepare for all this. You know, all of us have stood where you've stood today before, so we haven't forgotten how hard it is. Thanks to everyone else for coming in here. I hope you enjoyed this and learned a bit from it, and we'll see some of you in a few minutes. Thank you.
All rise. This honorable court is now adjourned.